This matter comes before the court at this time for what I have on the calendar as a scheduling conference. I'll just note, first of all, not only the length of the time that this case has been pending in this court, but also that this court has had very little involvement in this. And I do credit counsel to be able to work together without specific direction from the court regarding discovery and other matters. But this is the year 2026. This case was filed in 2023. Why is this case still pending in the Butler County District Court system?
Judge, this is a case where there was a significant foot injury, and my client, we had started with a lot of treatment, and we got an independent medical expert back in August after we had filed our statement of monetary damages. And that independent medical expert indicated that there was going to be a permanent disability. And so we were trying to seek as much treatment and get her to maximum medical improvement before we pushed for setting this case for trial. That took a significant amount of time. And my clients continued to treat since that time, and then eventually had to seek medical treatment outside of the Wichita area to try and get a doctor who could provide additional treatment because she has not completely healed. I think the case is finally ripe because we know that she is at the best that she's going to be. And so that's why we have now asked for a scheduling conference and to move this forward.
And the court's also aware of the motion for this court to compel mediation and then the response that was filed by the defense in this case. Was it anticipated, counsel, that the court would address that issue today?
Yes, Judge, we have a motion to amend monetary damages and motion for mediation that I think we were both anticipating to be taken up today. I apologize, Mackenzie, if that's not your understanding.
No, I'm fine addressing both of those today, if the court has time.
All right. There has to be a good reason to amend a statement of monetary damages, especially this late in the proceedings, Ms. Riling. So why should the court consider amendment of the statement of monetary damages that you originally filed, with noting that it was 2 years after the incident happened that this case was even filed? So what is the good reason that would compel this court to amend the statement for monetary damages as you have requested?
Right, Judge. And the good cause shown is, like I had previously stated, this is something we anticipated the plaintiff would recover better, and she just didn't. This is something that when we originally filed our statement of monetary damages, she had had 2 surgeries. They indicated that, with time, she was going to get better, and that did not happen. Therefore, she has had increased medical. Her medical is almost doubled. This is something that then we recently, last year, got an independent medical examiner and a life care planner. Her future medical has expanded and her disability rate has increased. These are all things that we anticipated wouldn't be as high when we first filed our statement for monetary damages. So there's good cause shown. There's also no true prejudice to the plaintiff. One of the things that I know the court looks at is, if there was an undue delay that's going to then harm the defense's ability to defend this. Since we don't have any scheduling deadlines, they have plenty of time to get an expert to counter our position. And so we feel that there's good cause shown that the amendment should be provided.
So her medical expenses have doubled, but her damages have quadrupled.
Her medical expenses have doubled. Her pain and suffering has, this with the increased disability rating, it's going to increase her pain and suffering over time as well. And we also added future medical expenses. This is not something that there was an unjustified reason for increasing her statement of monetary damages. The reason we didn't do it originally after we got the first permanent disability rating is because, again, we wanted to see how she would recover. and she didn't recover as expected. This is a much more significant permanent disability with pain and suffering and limitations than we had expected.
All right. Ms. Van Engen, what is the defense response here?
Your Honor, the defense does not believe that the request to amend her damages in an amount of $1.5 million is justified here. The original Rule 118 response was filed in May of 2023 and requested $500,000 of damages. And at that point in time, as the parties have noted, the incident giving rise to the plaintiff's claims had happened 2 years prior. So by the time that she had filed her original Rule 118 response, she had already completed the core medical treatment for her alleged injuries. She had had her 2 surgeries on her foot. She had been doing some PT, some chiropractic care. And then after May of 2023, she didn't do any new treatment. She only continued with the physical therapy and the chiropractic care that she had already been doing and had been doing for many years prior to this incident. And by December of 2024, her incident-related treatment had ceased. She wasn't doing anything to treat for her incident-related injuries. The only new appointments that the plaintiff has disclosed to us since December of 2024 was one appointment with a new orthopedic physician, which took place on May 13th of 2025. She did produce a new life care plan report, and the life care plan report kind of focused on sort of certain categories of things, and then that's what the plaintiff has justified or tries to justify her requested amendment on. One of those categories is persistent nerve pain in her left foot, but this is not a new or material change in her condition. She has always alleged that she has had continued pain in her foot since the onset of this lawsuit. Her first expert that was disclosed in August of 2023 stated that her left foot pain was chronic, permanent, and intractable, and that it would not improve over time despite any additional treatment interventions, which at this point should be considered palliative rather than restorative. She testified in her deposition in November of 2024 that she still had pain in her left foot. So this continued pain is not new. This is something that she knew long ago. And her first expert said she was going to have this pain for the foreseeable future, and there wasn't anything that she could do to remedy it. She also alleges that she needs a 3rd surgery on her foot, but in our view, this allegation is not supported in the records that was provided. The life care planner stated that the 3rd surgery was necessary and based that on the plaintiff's statement that she will likely need a nerve release in the future. But the one medical record provided by plaintiff from that orthopedic physician in May of 2025 did not reference any 3rd surgery, didn't reference the need for a nerve release, and didn't show any recommendations or discussions of a future surgery. The life care plan estimates that the surgery will cost approximately $13,000 and says that, her total medical treatment and surgical procedures will only be about an additional $40,000-ish. I'm rounding a little bit. And that is already, in our view, more than accounted for in her original statement of monetary damages, which was $500,000. She also focuses on the need for future treatment for pre-existing conditions. So she alleges that this incident aggravated her fibromyalgia. We don't believe that this is supported by the evidence. She's been treating for fibromyalgia since 2001. Her original expert, Dr. Hufford, stated that the treatment she's received for her fibromyalgia since this accident has been the usual and customary treatment and is not a consequence of the incident. Her treatment has remained consistent since before and after the accident. I think there was maybe a time where she had 1, maybe 2 additional appointments to treat her fibromyalgia, which really is not much. And while there may have been a temporary aggravation, at some point in time, the nexus between this incident and the aggravation is going to be cut and has to be cut. I mean, it's been 5 years since this accident, and fibromyalgia is a chronic condition that the plaintiff will unfortunately likely live with for the rest of her life. So at what point in time do we say this incident is the cause of her fibromyalgia or the worsening of her fibromyalgia, or just that this is a chronic condition that she unfortunately is likely going to have to continue to treat for the rest of her life? The same goes for her low back pain, which the plaintiff also argues is aggravated. She's been treating low back pain since at least 2016. Her original expert, Dr. Hufford, stated that at some point in time, her ongoing treatment for the chronic low back pain is going to revert to a baseline status, which cannot be attributed to the incident in question. Kind of like I said with the fibromyalgia, this is something that she's been treating for a long time. She was aware of at her initial filing and the filing of her Rule 118 response. At some point, this nexus between her low back pain and this incident is going to have to be cut. And we're 5 years post-accident. I would argue that at this point in time, that nexus has been cut. She also argues that she has an increased disability rating, but it's the defendant's opinion that that is sort of mischaracterized. So in her motion, she says that she received an updated disability rating of 25% and said that that was a 7% increase from her last rating in 2023. But the disability rating that was done in 2023 by Dr. Hufford was a whole person disability rating, which accounted for the low back pain, gait impairment, the foot injury, the weight gain, all of that. And her new expert, Dr. Barber, that was disclosed in this past August, stated that she believed Dr. Hufford's rating to be a reasonable estimate. She did not alter or change Dr. Hufford's opinion. She instead offered an additional disability rating, which was limited to the lower back. And so that 7% increase was that she had a new rating for the lower back specifically. And like I already discussed, she'd been treating and complaining of low back pain for many years before this incident. And at some point, the treatment of her low back pain cannot be attributed to this incident. So in totality, it's our position that none of the information provided by the plaintiff to support her claim for increased damages is new or changed. These were all conditions she was aware of and had been aware of and been treating at the outset of the lawsuit, and should have been accounted for, and in our opinion was accounted for in her original Rule 118 response. While we don't have a scheduling order on file, I do think that an increase in her Rule 118 response will certainly prejudice the defendants. I mean, this is the number that the plaintiff is allowed to present to the jury, and there's a big difference between presenting a damage request of $500,000 to a jury and $2 million. It's kind of one of those things that once you ring the bell, you can't unring the bell. So as soon as the plaintiff gets up at trial and requests the $2 million, that kind of anchors the jury's perspective and opinion on what her damages are worth, what the reasonable value is, and what sort of incident in terms of the severity of the incident we're looking at. So we would argue that the increase is prejudicial to the defendant, even though there is no scheduling order, and we would respectfully request that the court deny the plaintiff's request to amend her statement of monetary damages.
Well, Judge, I would just like to further comment. Again, this is something that our expert and life care planner that we hired last year agrees that she's still not back to baseline for a lot of these aggravated injuries. Everybody agrees at some point she will get back to baseline, but that's another reason why this case has taken so long, is she hasn't gotten better like we anticipated. And that's the justification or the good cause for the amendment of the damages. This is something she's had to continue to treat to try and get back to baseline. They've also, the third medical expert, or the second IME that we hired, indicated that she needs yet a third surgery. These are all things that we did not anticipate when we filed our first statement. We hadn't even hired
So
her.
you want the defense to be responsible for your initial error in anticipation, counsel?
Well, Judge, it's not an error. It was just at the time we didn't anticipate that it was going to take so long.
Which you later found out to be not true, or as the court might view it, erroneous.
Correct.
Not right, not correct.
Right. We were wrong in what we were anticipating.
Okay, you may continue.
And so, Judge, again, the whole purpose of the 118 disclosure is so that we don't have issues with unfair surprise and prejudice to one side. This is something that they can counter that our position with the damages with their own expert. They're not prejudiced by any kind of discovery cutoff date or deadline. They have plenty of time to address this, and the appropriate safeguard to address our statement of monetary damages or our value of the case is through cross-examination and competing experts. It's not based on a procedural rule to limit our damages at trial.
All right, Ms. Van Engen, anything further?
No, Your Honor.
All right. Court has reviewed the pertinent matters in the file, heard the arguments of counsel in regards to this issue. The court does once again note the extended period that this case has been pending. The court finds that the requested amendment is very much belated to the extent where the court would view, at least at the outset, as too little too late. It is not sufficiently supported by newly discovered evidence, and the court does deem an amendment of quadrupling the damage that they originally sought in this case to be unfair to the defense. Therefore, the court does not find a good reason to justify the amendment of the statement of monetary damages, and the court denies the request in its totality. All right, with that ruling made, counsel will turn to the motion to order mediation. This court strongly believes in the efficacy of mediation. When people participate in good faith, mediation is highly successful in resolving disputes and closing the gap between the parties, especially where you have an experienced, effective mediator. Ms. Riling's request will be granted by this court. Quite frankly, the court would have ordered it independently of the plaintiff's motion. In this case, you must, in good faith, attempt to reach a resolution. And I do understand the statements have been made about the parties are simply too far apart and it's a waste of time and effort. But I've heard that over and over during the course of this court's career. But often the people that have said that come back with a settlement. So as far as the logistics of it, I would entertain statements from counsel regarding the timing of the mediation in light of whatever else is going on in the case. Ms. Riling, let's start with you.
Judge, I think the case is ripe for mediation. We've taken deposition of the parties. We've already incurred significant costs. The matter is fully developed enough for a meaning evaluation through a mediator. It's our position that we don't delay in going to mediation because next step is going to be further depositions of experts, dispositive motions, only escalating litigation costs. So our request is that mediation occur as soon as possible to prevent any further increased costs.
What is as soon as possible, given your calendar, Ms. Riling? How soon could you schedule it?
Judge, I could schedule it in the next 30 days.
Okay. All right. That seems very appropriate to the court. All right. Ms. Van Engen, same questions for you.
Your Honor, I would agree with Ms. Riling. My calendar in March is fairly open, so I think between the two of us, we could probably work together to get something scheduled sooner than later.
Would you be the attorney that would be representing the defense at the mediation?
Yes, Your Honor.
Okay. And you are confident that whatever representatives for the defense is necessary would be available?
Yes, between
right.
all of the carrier representatives, generally there's always someone who's available to attend.
All right. Again, the court will grant the motion for mediation and compel mediation within a reasonable time. It's contemplated by the court that that could be scheduled as soon as within 30 days. I just hope that there's an agreement on a mediator. I know that there are a number of qualified mediators in both the Wichita and Kansas City metro areas. Do we have at least some understanding as to who this mediator might be? Ms. Riley?
Yes, Judge. We've already agreed on Chuck Hess out of
Okay,
Wichita, and we had reached out with him, and he's got availability, so that's not a problem.
very well. Then I'll expect that scheduling efforts be made with Mr. Hess in good faith from both parties this week. All right, I'm going to set a status conference date in this case well after the mediation has taken place and perhaps for the mediator to generate a report, whatever it might be. I don't want to lose track of this case anymore. So I'm perhaps looking maybe something late April. I don't have a whole lot of settings left in May. Let's look at our April calendars. Perhaps I'm being overly optimistic regarding timing. I think this would be about 6 or 7 weeks down the line. Monday, April 20.
That works for me, Judge.
That
I'd be
also works for
looking
me.
at another 10 o'clock setting like today by Zoom. Court will conduct a status conference in this case, again by Zoom, to review the then status of the case if necessary. Obviously, if mediation results in a total settlement, perhaps that won't be necessary, but I'll otherwise count on counsel appearing by Zoom 10 o'clock a.m. Monday, April 20th for a review of status. All right. Though I don't normally do this, I think in this case, I'm inclined to assign the responsibility for documenting by journal entry the court's ruling on the statement of monetary damages to defense counsel and the order granting the mediation, naming the mediator to Ms. Riley. And I'll look forward to, and then I'll need Ms. Riling's order to state the status conference date and time. I look forward to receiving those in the court's queue here over the course of the next few days. All right. Ms. Riling, are you aware of anything further that the court needs to address in this case at this time?
No, Judge.
Now the defense goes even further by highlighting something that could completely undermine the plaintiff's case: pre-existing medical conditions. According to the defense attorney, the plaintiff has been treating fibromyalgia since 2001 and chronic lower back pain since at least 2016. In other words, these conditions existed long before the accident ever happened. The defense argues that while the incident may have temporarily aggravated those conditions, it cannot be blamed for years of ongoing symptoms. At some point, they say, the connection between the accident and those health issues simply disappears. And here's the defense's biggest concern: allowing the plaintiff to raise the damages from $500,000 to nearly $2 million could unfairly influence a jury before the trial even begins. At this point, the plaintiff's attorney tries one last time to justify the increased damages. She explains that when the original claim was filed, the legal team believed the plaintiff would recover faster and return to normal health. That expectation turned out to be wrong. As treatment continued, doctors determined the injuries were more severe than originally believed, which is why the damages estimate changed. But the judge quickly cuts through that explanation with a sharp question: should the defense really be responsible for the plaintiff's earlier miscalculations? The courtroom grows quiet for a moment as the attorney admits that their original expectations about recovery were simply incorrect. And then comes the moment that changes everything. After hearing both sides, the judge delivers a firm ruling. The court finds that the request to dramatically increase the damages is simply too late and not supported by newly discovered evidence. Quadrupling the damages demand at this stage, the judge explains, would be unfair to the defense. With that, the motion to amend the monetary damages is completely denied. However, the judge isn't done. Recognizing how long the case has already dragged on, the court orders both parties to participate in mediation within the next 30 days. The message from the bench is clear. This dispute needs to move forward, either towards settlement or trial. But the days of endless delay are officially over.